you for those examples of the FBI's good work in your opening statement. I think we all appreciated what the FBI has done. My first question is this: would you reopen the Clinton investigation if you discovered new information that was both relevant and substantial?
It's hard for me to answer in the abstract. We would certainly look at any new and substantial information.
Yeah. In general, and let's impersonalize it, in general, if you discovered new information that was substantial and relevant, you would reopen an investigation, would you not?
Again, even in general, I don't think we can answer that in the abstract. What we can say is if any investigation, if people have new and substantial information, we'd like to see it so we can make an evaluation.
Okay. Let me give you some examples and mention several new developments that I think have occurred and ask you if you have become aware of them. The first example is what the chairman mentioned a while ago. An employee at a company that managed former Secretary Clinton's private email server said, quote, "I need to strip out a VIP's, very VIP, email address from a bunch of archived emails. Basically, they don't want the VIP's email address exposed to anyone." I assume you're aware of that.
I'm aware of that.
Okay. The same employee called a new retention policy designed to delete emails after 60 days a, quote, "Hillary cover-up operation." And you saw that, did you not?
Say the last. I'm sorry, Mr. Smith, I couldn't hear the last.
Same employee called a new retention policy designed to delete emails after 60 days a Hillary cover-up operation. You saw that?
I don't know that particular language.
Okay. We'll get you the source, but you can take my word for it that that's what he said.
I will.
Another example, a former Clinton Foundation employee who also managed the Clinton server destroyed devices used by former Secretary Clinton by smashing them with a hammer. You're aware of that?
Yes.
Okay. Two employees of the company that managed former Secretary Clinton's server recently pled the Fifth Amendment to Congress to avoid self-incrimination. You're aware of that?
Yes.
Okay. And then lastly, 15,000 more work-related emails were discovered, though there had been an attempt to wrongly delete them. And you're aware of that?
I think we discovered them.
Right. To me, Director Comey, what I've cited are not the actions of innocent people. There is a distinct possibility that Mrs. Clinton or her staff directed others to destroy evidence in a government investigation, which of course is against the law. So I would urge you to reopen your investigation. Do you want to comment on that?
I don't.
Okay. I know you can't tell us whether you have or have not, but I believe I've given evidence of new information that is relevant and substantial that would justify reopening the investigation. My next question is this. I know you've granted immunity to a number of individuals, but if you had new information that is relevant and substantial, you would be able to investigate them further, wouldn't you?
Not to quibble, the FBI doesn't grant immunity to anybody. The Department of Justice is able to grant very different kinds of immunity. Yeah, and immunity, if new and substantial evidence develops, either that a witness lied under a grant of use immunity or under any kind of immunity, of course the Department of Justice can pursue it.
Okay.
Nobody gets lifetime immunity.
Right. Okay. Thank you, Director Comey. Last question is this. As chairman of the Science Committee, I issued the FBI a subpoena on September 19, 2016. The due date for a response was 2 days ago, September 26. Bureau staff has still not provided the requested information and documents. Yesterday, we pointed out to them that the Science Committee has jurisdiction over the National Institute of Standards and Technology, which sets standards for the Federal Information Security Modernization Act of 2014. I trust you intend to comply with the subpoena.
I intend to continue the conversations we've been having about the subpoena.
Yeah.
As you know, we've made a lot of documents available to at least 6 committees. And the question of whether we should make them available to another committee is something that we're struggling with, but talking to your folks about.
To me, there's no struggle. If we have clear jurisdiction, which we can demonstrate, it, I think, obligates you to comply with the subpoena.
Yes, sir. We're not trying to be disrespectful. We're just not sure we see the jurisdictional issue the way that your folks do, but we're continuing to talk about it.
Okay. Thank you, Director Comey.
Would the gentleman yield?
I'll yield to the gentleman from California.
Thank you. The chairman of the full committee had asked something earlier, and I just want to point out and ask it to be placed in the record. According to the Maryland Code of Ethics, 19301.11, it specifically prohibits a former or current government officer or employee from acting as a counsel to someone that they represented in government. I'd like that to be placed in the record. In light of the fact that the Maryland Bar
Without
has
objection, it will be made a part of the record.
in light of the fact the Maryland Bar has this prohibition, would that have changed your view of allowing her in and saying you had no authority?
I'm not qualified, nor am I going to answer questions about legal ethics in this forum. The FBI has no basis to exclude somebody from an interview who the subject of the interview says is on their legal team.
Okay. Thank you, Director Comey. Thank you, Mr. Chairman. Yield back.